Hello, hello, hello. I'm Kirsten Hildebrand, and this is attorney Daron, and we are here to do the Hildebrand Law Firm podcast for today. So we are going to be talking about probate and what happens during the course of probate. We're going to break it up into three different sections, and section one is going to be kind of what happens in the very beginning of the probate process. Well, first of all, my first question, Derek, is what are the reasons why someone would go into probate? What is that?
So the main reason that someone goes into probate, and probate is at its base, it's a court overseen process where somebody who has assets in their name but doesn't have either appropriate estate planning, adequate estate planning, maybe has issues with their estate planning, but those assets that are in your name need to go to your heirs. And obviously banks aren't just going to say, hey, you're the son of so-and-so, you get all of his money. They have a formal process that's required, and that's where we get into the probate process. In order to have the bank acknowledge and have a family member, or who would we would have someone appointed as a personal representative, who's usually a child of the decedent. In order for the bank to honor that person's authority, you need to go through the probate process, and you need to get what's the focus of today, which is get appointed as the personal representative and open that probate.
So before you are appointed as a personal representative, what can happen? Because I'll tell you what, I've heard plenty of stories coming from clients, and particularly in our litigation arena, where somebody passes away and within 30 minutes, maybe even before they pass away, people are already in the house, dividing things up, scurrying around, figuring out where's the strong box, where's the money hidden, is it in the rafters, is it in the freezer, and all of this stuff is like disappearing overnight, it seems. And so that's not an uncommon thing to have happen, is it?
No, not at all. The line in the sand is that before a personal representative is appointed, nobody in the family has any real authority to go and go into the house and pull out personal property or pull out cash from the safe, or do really any of those things that need to be done. Of course, in practicality, you see people do that all the time, which oftentimes, if not almost always, leads to disputes, leads to issues of he said, she said about who has what, and then obviously also in cases leads to litigation.
And that's interesting because it's almost like a bad divorce where you have two warring people who are trying to like grab everything from the house. And then it really never results in less legal fees spent. It usually results in far more spent in legal fees because then there's this uncertainty and there's this lack of trust, and also just a lot of angst about, okay, well, where did grandmother's ring go? I don't know. Do you know? And so let's say there's 3-4 kids and nobody is claiming that they know where grandmother's ring went. That can be very tough, and really result in people not being able to just go, okay, at least I know that my sister has it, and while I might not be totally okay with that, at least I know that it did go to somebody as opposed to being completely lost. So this really helps with the oversight of the assets being distributed in a way that's above board, that's fair, reasonable, and in accordance with the wishes of the person who has passed away, right?
Yep, absolutely. And you see in a lot of cases too where there's accusations of a will going missing or a trust going missing. Most often a will goes missing where somebody who has access to the house, has access to the safe, has access to the important paperwork. Accusations that a will goes missing obviously has a huge effect on the probate proceedings that are going to come, because the will is that set of directives to the probate court about how the decedent wanted their estate managed. And so you do get a lot of disputes about that. For my money, when somebody's coming into me and meeting with your friendly neighborhood probate attorney to figure out what the next steps are, whether or not somebody had a will, whether or not the siblings are getting along, whether or not we have contact information for the siblings, those are obviously all important considerations for me when you meet with me to start. But to go back to our first stage of a probate, your first stage is that appointment of a personal representative so that somebody can legally go in. And if there is a will, find the will and file it with the court. And if there is personal property or there is something that needs to be done immediately, then that personal representative can be formally legally appointed and can have court oversight and court authority to do all that they're doing.
So let's suppose there is no will. How do you know who the personal representative should be?
And you see this often in cases where if you have siblings and they're the next in line, so say, for example, mom passed away, dad had predeceased, they leave 3 kids. You hope that the 3 kids can agree on who should be the personal representative. But if they don't agree and there is no will, a lot of times what will happen is the 2 sets of siblings can file these sort of competing petitions for administration. And what the court will typically do is either appoint a third party, or if there is some legitimate reason why one of the kids should not be the personal representative, whether they live really far out of state or remote, whether they have some issues with financial misdealings in the past. Most often, though, a court is simply going to appoint a third party personal representative who's going to be an area attorney who, unfortunately, is most likely going to cost you a lot more money.
Interesting. So to not do a will and give instructions to the court about who you want as the personal representative can actually lead to a larger expense against the estate than if you had a will and at least named who your personal representative is.
Certainly, and I've seen cases as well where people do compromise and they say, in an 8-child family, 2 of the kids could be co-personal representatives. But in those cases, too, if they don't agree, it really causes issues that can result in a lot of litigation. And we've seen that firsthand. So it definitely is best to have that estate plan prepared, to certainly have that personal representative be nominated. Of course, avoiding probate in the first place would be the better step. But if you do only have a will, certainly you want to be able to name that personal representative in the will.
And the other benefits of having a will include what exactly?
Yeah, so under Wisconsin intestacy law, which is the law that occurs when you don't have a will, there's a sort of default presumption of who gets your stuff. With a will, you can really decide for yourself who you want to get what. You can cordon off 10% for a charity, or 50% for one child and 25% each for the other 2. You do have some more flexibility with that will over who gets what.
So in other words, the state of Wisconsin will apply these basic rules to your case if you don't put a will in place that overrides those basic rules. And my guess is that there are situations where people would not necessarily love the outcome of that. So, for example, if you were not preparing a will and you had one sister that's alive and 3 nieces, and you really wanted everything to go to the 3 nieces, can you just say that? Or do you have to get that on paper? And what would happen if you didn't get that on paper?
Yeah, you definitely have to get it on paper. It has to be more than that. A will does have to be witnessed by 2 adults, 18 years of age or older, not incompetent. Generally speaking, they should be unrelated to you as well, which is probably an obvious one. You do see that situation, though, too, where mom passes away and has 2 kids. If one of the kids is predeceased, I think a lot of people expect that all of mom's inheritance would go to the surviving child. However, if that predeceased child had children of their own, under Wisconsin's default rules, those children would actually receive 50% of the estate split amongst them. So it can take people by surprise when you don't have a will, you don't have a trust. Those default rules in Wisconsin are definitely not one size fits all.
And if you have a sister that's alive, but you want everything to go to your nieces, under intestacy laws, it would go to the sister, right?
Typically speaking, yeah, depending on what other family members there are.
Yeah. So in other words, it gets complicated.
Correct.
And it's not necessarily what the wishes of the individual are. So that's a good reason to to put a will in place, put instructions in place to the probate court so that then they can be followed and implemented. And that's the whole purpose of the probate is, at least when you have a will, to implement those rules. And even if you don't implement those rules, the probate court is still going to take over and they're going to implement the state's rules.
There's no sticking your head in the sand when it comes to estate planning. It's going to happen one way or another.
Well, that is very informative, and thank you so much for joining us today, and we'll do part 2 next time.